Hi everybody, it's Friday the 21st of October 2016. This video is about the changes in relation to the Deregulation Act, which came into force in October 2015 and will now be hitting a lot of landlords who are looking to serve Section 21 notices. So I just wanted to go over the different parts of it so that you were clear on what was necessary if you wish to serve a Section 21, particularly on your tenant, or want to follow the rules on the new tenancies. A few things that you need to know. The first thing is that there is now a new standard form for Section 21. Whereas before we had Section 21 4A and B, there's now a standard one which can be downloaded from the government website. And this is the new Section 21 which can be used in either case. So actually that's good news. It's less confusion. There's one notice to serve. It's very clear and concise, and there's no date required for eviction. So it should make things a little bit simpler. However, there are other things that will make it a lot more complex. You really do need to get your ducks in a row if you want to comply and make sure that you are successful in an eviction, particularly under Section 21. And the examples I've got here are the things that you need to know are the condition of the dwelling houses or the common parts, the health and safety of occupiers and dwelling houses, and the energy performance. This means that you must provide an energy performance certificate, a gas safety certificate before the tenancy begins, and if you want to serve a Section 21 notice at a later date, you'll need to prove that the tenant has been provided with these two documents. If they don't, then you won't be able to rely on the Section 21 notice for possession. So at the start of each AST, landlords are now required to provide a booklet which is called How to Rent, and this changes all the time, so you might want to download that again, and it's available from the DCLG website, the government website, and if you just Google How to Rent, the checklist for renting in England, you should be providing your tenants with a copy of that as well. The Section 21 notice, good news really, that does simplify things. However, there are different provisions now that mean that your tenants can fight your eviction notice under new grounds, particularly where they claim disrepair, and that disrepair is backed up by a local authority notice. Section 21 will no longer be valid until the repair issue has been dealt with. This does leave the door open for tenants to be difficult when it comes to repairs and maintenance under Section 21. They could be using it as a scapegoat, if you will. Where there are genuine repairs, of course, we agree that a tenant should have a right to have those done, and where a landlord's evicting because he doesn't want to do works which he should be doing, that's wrong. And this regulation is there to protect tenants from that. However, I think there will be occasions when tenants may use it as a way of saying that things are wrong when perhaps they're not, in order that the landlord can't gain possession under Section 21. So be sure that any maintenance issues are dealt with before issuing your Section 21 notice. So overall, the form is more straightforward. Tackling retaliatory evictions could open the floodgates for tenants to submit more sham disrepair. That's the only thing I would say about that. Much of the legislation that's changed in the Deregulation Act has really been there to protect tenants and strengthen tenants' rights. There's not much in there for landlords, to be frank, other than the fact that Section 21 is now simplified. So make sure that before you start your tenancy, your tenant has the How to Rent booklet. You can no longer serve a Section 21 notice in advance of a tenancy as well. You need to serve it after the 4-month period, not prior to or during the commencement of a tenancy. So you can't serve it early in order to then say that I've already served it later. It no longer works. You need to wait out your 4-month period as a minimum, or 10-month period if you're doing it at the end of the 12, and it's a fixed term 12-month with no break clause. We would always say put a break clause in at 6 so that you could serve at 4 should the need arise. So the changes hopefully will help landlords to encourage landlords to operate best practice. That's what the government is saying. Landlords really need to keep on top of maintenance issues. You also need to make sure you're supplying your tenant with the gas safety certificate, the How to Rent booklet, the energy performance certificate, and these are just a few of the things that you need to be really careful on. So if you need any advice on that, as usual, drop us an email at the usual address.